Good morning, good afternoon, everyone, depending on where you are. I will allow a few seconds for my co-panelists to join us. Welcome, everyone to this webinar organized under the aegis of Thought Leaders 4. Thanks a lot for them for putting this together and inviting us to speak. My name is Nicolas Leroux. I'm a partner at SFC, Swiss Forensic and Compliance. We are a boutique, a provider of corporate intelligence services based in Switzerland, as the name implies, with a lot of activity in asset recovery. And I'm going to moderate this panel. Before we turn to the substance, I wanted to give an opportunity to my co-panelists to introduce themselves. We have a great panel today with 4 investigators, including myself, and 1 lawyer, Ed. Gretchen, would you like to go first?
Sure, of course. Hello, everyone. My name is Gretchen King. I'm a co-founder of Vantage Intelligence. Vantage is headquartered in London. We also have an office in Dubai, where I am today, and New York.
Great, thanks. Alison, you're the next one on my screen.
Good afternoon, everyone. My name's Alison. I'm a senior associate at Greyhawk, a corporate intelligence firm based in London. We specialize in Europe, the Middle East, and Africa, but our investigations often take us to countries way beyond that.
Thank you. Roy.
Hi, everyone. My name is Roy Pollitt. I'm a partner at FRA based in the New York office. We're a 25-year-old boutique forensic investigation company and look forward to speaking with you all today.
Great. Ed.
Sure. Thank you. Good morning, good evening, good afternoon, wherever you are. My name's Ed Davis. I'm with Secure Law based in Miami, and my role today is to be sort of the client or the instructor with regard to these issues. My firm is a very heavy consumer of investigative services. So Nick and others asked me to be part of it, and I'm thrilled, and it's a privilege to be part of it.
Thanks a lot to all of you. So just a point on housekeeping. You have a chat function, which I think you can all see if you click on the bottom of the screen. The chat function is for you to ask questions. Of course, we will have a short session at the end, perhaps 10 minutes to respond to questions or comments from the audience. But of course, as all webinar hosts, we want this to keep as interactive as possible. So if you do have questions, feel free to post them during the course of the webinar, and I'll keep an eye on this on that chat, and we'll try to address those questions or comments during the webinar. So the topic today that we have is corporate investigators, how to leverage them or use them to maximum effect. The premise of that webinar is that as investigators, we work a lot with law firms, with lawyers, and we find that sometimes we have a feeling that law firms could use us to more effect. And we also feel that sometimes lawyers, and I'm a lawyer myself by training, I used to be a practicing lawyer, have maybe difficulties in understanding exactly what investigators do, how they operate. There might be a few myths that we want to debunk. So we thought, let's try and put everything on the table. Let's try and be as transparent as we can. And let's try and help those lawyers use us to maximum effect, which is in the interest, obviously, of everyone, us as investigators, the law firms, and ultimately their clients. We're going to try and address 4 topics today, which are, and it's quite ambitious, which are, first, what do investigators actually do, and what do they don't do, which is equally important. The second one will be, how do investigators operate? What's the technique that they use? The third one would be, how can you manage your investigators effectively as a client, as a lawyer? And the fourth one will be, at the end of the process, how do you ensure that the information that you receive is correct? And of course, your investigators should have done that, but it's always good to understand how they think about this and how you can approach that. For each of those topics, one of the 4 investigators will say a few words. We'll try and kick off the conversation. It will be me, then Alison, then Ryan, then Gretchen. And for every of those topics, Ed will be our sparring partner because, as he said, he's a he's a heavy consumer of the services, so he can look at this from the other side of the fence, which is the side of the fence of most of you in the audience as lawyers. So that's for the approach and the setting of the webinar. I'll start with the first topic. I'll try to be brief because we have a lot to cover in the other topics. But what do investigators do and don't do? When we discussed it before the webinar, when we did a prep call for this, what we wanted to emphasize was the fact that investigators can both do more and less than you probably think as a lawyer. They can do less than you think, in the sense that the reliable corporate investigators, which we all are, obviously, basically don't do anything illegal. Basically, we don't hack or steal. That should be sort of obvious. I mean, that sounds like something obvious. In our practice, we often come up with situations where clients, ultimate clients, but even often actually law firms, come up with strategies or ideas which are dubious, to say the least. We had a case recently in my firm where the law firm came to us with a very specific request. They said it was something regarding succession of someone, a wealthy person, and they wanted to have a specific document, which was a paper document. And we said, but do you know where that paper document is? And they said, yes, we know. It's in the drawer, in the office, in the desk of the opposing party. And we're like, okay, so the only way to get that document is to be burglars, to break into the house and get this. We're not going to do that. And they hadn't really realized that. And it's the same with hacking. I mean, hacking somehow maybe seems a bit more harmless, but it's effectively the same. The other thing is that often lawyers come to us with very, very specific requests like this, like, I want to know the amount in that bank account. So first, it's extremely difficult to know that. And even if we were to find the information, and that leads me to my second point, even if we were to find the information, that information becomes invalid almost immediately as soon as we get it, because yes, there might be that amount in the bank account, but 5 minutes later, the amount might have been wired somewhere else. So in those cases, we try to draw the attention of the clients, of the lawyers, to the fact that we can do more than they think. So we can do less in the sense that we're not going to do those things, which are very specific and probably would end us, would put us in jail, and our clients too. But we can have, as investigators, we can have a different view of the case, and we can think of things that lawyers usually do not think of. The way that an investigator thinks is probably a bit more circuitous than the lawyer, in the sense that we will find information in ways that are unexpected, which often come down to luck or to whatever we find, and then we can find the information in those ways. One example that I will use, and then I will leave the floor to Ed, was something last year where a case where we were asked to identify bank accounts in Switzerland, which is something that comes up a lot, for a wealthy Eastern European businessman. And we did find, not the account, but we did find the bank and the relationship manager that this person was working with. And the client was very happy. The way we found it was because, and I'll give the example because it's very telling, was because we looked at the entire environment of that person. We saw that they had a house on the French Riviera. So we looked at that house and we saw that there had been some litigation in relation to works at the house with a local builder or local plumber, I think. So we went to fetch the documents from that litigation in the local court in Nice. And in that local court in Nice, one of the workers, the plumber, I think, mentioned the fact that he had been in touch with the client's bank in Switzerland and with Mr. X at the bank in Switzerland in relation to the payment. And that's how we identified that this very sophisticated businessman who had built a very complex array of shell companies and techniques to hide his wealth had basically been given away by the plumber in Nice. So that's how you find information, and that's not how most of the time lawyers think that we can find information, or how they would look for information, which is, to our point, investigators can do more than you think, and they can do less in the sense that they're not going to break windows or hack computers most of the time. Ed, would you like to comment on this?
Sure, Nick. Sure. That's a great introduction to this area, which I think really comes down to how do we manage client expectations, right? We talk to clients about what investigations can and can't do. And they have to understand that there's no magic, there's no secret button that you guys have, there's no secret database that you can press. The problem is, and I don't mean to say this lightly, is that we're dealing with 40 or 50 years of detective TV shows and other things that people, especially more unsophisticated clients, come to the process with, and they think we have, or NCIS, where they can type in theoretically a database and look up a piece of information. Number one, even if that were true, which it isn't, they're government, and governments have resources that individual investigators simply don't have. Sometimes derivatively they can get them. So I think it's very important that we manage expectations. For us, the biggest problem is when clients come to us with information that they've received from an investigator. Sometimes, and at least all of the problem cases I've had, involve those situations where they've come to you with something that they've basically been ripped off. They've been reloaded by a less than honest investigator, and I'll put quotes around that because they're not real investigators, and they believe what they've been told, and you then become someone adversarial with them as the lawyer, saying, well, I'm sorry, that's just not been vetted, it's not, and now you're in a position and they're coming to you for legal advice, so now we have to deal with, and we become adversarial at times even with the investigator in those situations. So these iffy investigations are very concerning to us. The industry does need some standards out there, and everybody on this call, and we've worked with all of you, have hold yourselves to very high standards. So I think one of the issues we have to confront is that, and I know it's going to be picked up later by someone else on this point, how do we deal with those situations? The other issue is that you have to tell clients that investigations are not like, it's more like baseball, to use an American phrase. You go up to the plate, and if you hit 50% of the balls, you are an amazing hitter, okay? If you hit 30%, 35%, you are still an amazing hitter. I think one of the issues that we have, and I'm sorry to use an American sports analogy, but we can't guarantee that we're going to get information every time. And clients want some sort of guarantee before they spend the money, and that becomes very difficult. So we have to coach them and counsel them that that's not always possible. And lastly, one of the things that we try to explain, and we work with investigators on this, is the difference between intelligence and evidence. We are interested in both, but really the gold standard is evidence. What can we put in before a court that we can use to influence a trier of fact to come to the resolution that we want in the court, right? And so we want evidence that we can use, whether that's documentary evidence, whether it's an interview, whether it's some other form of physical evidence that moves the trier of fact. And sometimes we can't get that. We get intelligence saying, we know that's there, but through our sources, and I think Gretchen's going to cover some of this, and Allison, we can't actually give you that. We know it's there, but you're going to have to figure out a way. So the lawyers have to collaborate and put their creative hats on to figure out, how do I turn that intelligence into evidence? So I do agree with you, your fundamental premise that investigators can do more than people think, and they can do less than people think, which is a little bit ironic, but it is really true. Proceeding or a bankruptcy proceeding and turn that intelligence into evidence, because you guys have bird dogged it for us. We know there's a bird in the bush. We have a dog pointing at it. We just got to go flush that bird out, and we do it with discovery.
Yeah. Thanks a lot, Ed. I'm not sure I got the American football analogy. I actually didn't get it.
Baseball.
Nonetheless.
Well, definitely you didn't get it. So
yeah, I didn't get it. Okay. Thanks a lot. Our second topic, so we've tried to cover what investigators do and don't do. Our second topic is, and just for my co-panelists, if you want to pitch in at any time, of course, feel free. The second topic I'm going to turn to Alison now is, how do investigators operate in practice? What do they do?
Sure, thanks, Nicola. Before I start, I must apologize. I'm really struggling with a cold, so if my voice starts to disappear, I'm sorry, that's why.
You're fine so far.
We'll see how it goes. So Nicola has set out why you might use an investigator and the kinds of things we can do. I'm going to talk a bit about how we actually do our work. And before you worry that I'm going to bore you with the hundreds of thousands of resources that we use, I'm going to try and divide them into three what I'll call channels through which we operate. In doing that, I'm going to focus on what I see as some of the misunderstandings or misconceptions that lawyers and their clients have about how we work. And I'll be very interested to hear if Ed's seen those amongst his peers, amongst his clients, or if any of my panelists agree that they're there. So the misunderstandings as I see them are at two almost opposite ends of the spectrum. So on the one hand, I think some people think, well, it's lots of sort of public records work. So public records, well, that means it's easy, it's open, it's online, it's there for the taking. At the other end of the spectrum, there are some people who think that private investigators are basically spies, and they're doing kind of spy-like spooky things. I know Ed spoke a bit about CSI. It's that kind of thing. And as is so often the case, the truth is probably somewhere in the middle. We're not spies, I'll say that. And I'm going to try and present the reality very quickly across these three channels. The first channel that I'm going to talk about is the public records, and I don't know if my co-panelists would agree, that's the one that we start with, and it's the one that takes up the most of our time, especially at the beginning of an investigation. It's sort of shaking the tree to see what falls out. So by public records, I mean things like company filings, property records, social media, birth, marriage and death records, aircraft registries, ship. I won't bore you, but there are hundreds, if not thousands, of public records that we could consult, depending on the requirements of an investigation. Just to return to that point that public records equals open, easy, free. I think, yeah, public is sometimes a bit of a misnomer for 3 or 4 reasons. The first one is that there are still plenty of countries where plenty of records just haven't been digitalized, and we are still sending people to a land registry to pull a hard copy document. Certainly, I've just worked on an asset tracing where I was looking for property records in Egypt. There is no centralized, comprehensive national property register in Egypt, so we had to send people to local offices, and they were down there in stacks of documents. So there are still lots of records that just you can't go to a website and find them. The second reason why I think public is a bit of a misnomer is that just because things are online doesn't mean that they're easy to search. To take a very basic example, I think a lot of people, you'll be familiar with Companies House in the UK. I can very easily type in the name of a company and find the names of its shareholders in its filings. I can't do the reverse. So I can't type in the name of a person and get back a list of the shareholdings they hold in UK companies. So we have to find ways around that. We have to think outside the box a bit in terms of how we get that information. The third sort of problem with the public records is that we are rarely just stuck to one jurisdiction. So, just because we're looking for, say we're trying to work out the ownership of a yacht that's moored in Saint-Tropez, we might start with the French records, but that might take us to the BVI or the Cayman Islands and then back to the UK to find that the owner is a Russian businessman, for example. So you have to know a little bit about a lot of countries and be able to hop, skip and jump between them. And the fourth thing about the public records is that they are expensive. So my firm alone spends probably tens of thousands of pounds every year just buying access to filings, to commercial data sets, and it really adds up. One point I did also just want to acknowledge very quickly, and again, I'd be very interested to hear if my co-panelists have experienced this. But I think in the last year, we've noticed an increase in inquiries where clients, lawyers are asking if we use things like AI, or ChatGPT, or web scraping in our investigations. And the answer is yes. I think, all investigators will try and stay on top of new technologies and think about how they could use them in their work. But again, it's maybe something Roy will talk about. It's important to manage client expectations. Rarely are they a silver bullet that's going to solve your investigation. They're often helpful, but you can't rely on them completely. So that's the public records. I said I'd talk about 3 channels. The second one, very quickly, is talking to people. So you might call it source inquiries, you might call it human intelligence. It's talking to people. It's finding out information from other people. Sometimes we do that directly. Sometimes we do that through a trusted contact because they have better reach than us, or a language we don't have, or sometimes just for reasons of discretion. Sometimes we're getting information on an informal basis. Somebody might point us towards something that we didn't already know about. Sometimes it's more formal, so we might be finding somebody who could eventually offer testimony. I think most investigators have a sort of stable of trusted contacts that they've known for a long time, that who can make those inquiries for them. But sometimes you're just asked about a jurisdiction you don't work in that often, and part of our job is finding reliable, trustworthy people who can make inquiries. And using somebody for the first time to help you with that is it's always a bit risky and needs careful management. And I know Gretchen's going to talk a bit about the challenges of that later on. The third and final channel I wanted to talk about is surveillance. That is rarely our first port of call, if ever. We use it very sparingly. That's for probably three reasons. The first one is that it's super expensive. So a 5-person team in London for a week could easily cost you £30,000 because you need 5 people to cover all eventualities. It costs a lot. The second reason it's something that we don't use that much is that it's just very difficult. So you might remember the case of the Kazakh businessman Mukhtar Ablyazov, a Kazakh businessman fraudster. I believe it took investigators well over a year to track him down to his villa in the south of France. So even good teams, and we work with ex-police, ex-British Army operatives, even good teams, it can be hard. And the third reason, the third challenge is that even those great teams that we have sometimes lose people. They're very unlucky. It can be, as simple as a traffic light turning red, space of a second, somebody's gone. So surveillance is something that we use, I think, sparingly and with a very specific, very clearly defined purpose. So that was a whistle-stop tour of how we do investigations. I could go on and on for hours, but I'd be interested to hear what everyone else thinks, especially Ed, about those misconceptions, if that's something that you see amongst your peers and your clients.
I do. Before I go, maybe anybody else?
Yeah, sorry. Before you go, I just wanted to congratulate you, Alison, because you actually answered the first question that we had in the chat, which was, how does AI affect your work? So you addressed that.
Oh, I hadn't seen that. Okay, great.
Yeah, thanks.
I would throw in, before Ed takes over, one more point about, I guess, open source, which is how lawyers and the courts look at these data leaks that are now happening nonstop. So even though it's stolen information, but we can access it online, how do the courts look at that?
By the way, I love the data leaks, as you would have expected.
So do I. I think we all do.
I love them.
We all do.
And frankly, I think the courts. It depends on the country. For example, I think in the UK influenced jurisdictions, the court tends to go. It goes to the weight that the court gives the evidence, as opposed to the United States, where in certain types of proceedings, evidence can be excluded because it's obtained improperly. Right. So far, information that's come in from some of these leaks have, at least in my experience, we've been able to get it into evidence. So it is, but you still have all the other evidentiary issues you got to deal with, whether that information had been obtained through a leak or obtained through an investigator. So there's so much that Alison has covered that, we could do a whole seminar just on this one, each of these topics. But for me, I think it's all about, what I'm looking for in an investigator is, I don't want a cowboy or someone who steps over the line. But I also don't want someone who's desk bound and shy about going out. So to me, it's finding that right balance of someone who has, the sensitivities and thinking about all of the issues that we're going to see, not just getting to the goal, but also the blowback that could come from doing something wrong, right? I mean, you have to be very careful that you're achieving that balance, because you could easily take a good case and make it a bad case by doing something wrong. And we want to be very careful that that doesn't happen. So I want to echo what Alison said about surveillance. I've had so many experiences with surveillance, and clients love it because it's the sexy part of what we do. And clients want to get someone out there. And I've had them go really well. I've had them go really poorly, and I've had some just fizzle. I had one where I represented a Scottish insurance company that the investigator decided to go up into and under a porch area and get a garbage can and do what we call garbicology or dumpster diving. And in the process, dropped the garbage can, hit the car alarm went off, the garbage can rolled down the street. He then proceeded to notwithstanding all of that happening, take the garbage can and dump it into his trunk of his car, and then throw the garbage can on the front yard and drive away. The person who was being surveilled videotaped all of that, followed this person and to a back of a shopping mall where they were sorting through it, and all of that was on video. So you can imagine, the Inspector Clouseau approach to that was really problematic for us in so many ways. I will say on the AI side, really AI for us is about helping manage large data sets, right? It's how do we parse down and work through these large data sets. It's really not come too much into our world with regard to this type of work. This is really a hands-on work. So the sequence of the investigation is the critical thing. Having that dialogue back and forth, 100% agree that you start with public records. You build the foundation of your investigation with public records, and then you go from there. Human intelligence being the second approach, and then you build sort of the wedding cake, if you will, as much as you can up, and figure out where that takes you. But it is a collaborative process between lawyer and investigator, and sometimes clients as well. So again, I can go on and on, but hacking and stealing, absolutely out. I had an investigator once call me on the phone and say, I have the mail from this person's mailbox. And I said, where are you? And they said, I'm near the mailbox. I said, walk back and put it back. That investigator was never hired again. But you can imagine the issue there would have been a crime to steal someone's mail. Even though it was probably good information, we wouldn't do that. So anyway, I'll stop.
And Allison and Ed, to your point, this approach, the phased approach, is important. And I think it's important for a number of reasons. One, we have to build that foundation from which to generate our leads, to see where kind of the best is the juice going to be worth the squeeze, and where we want to direct our phase two, whether it be boots on the ground or what have you. And the other reason is clients, sometimes they want to just find out the answer, right? Just get us to the end. But like doing it by this approach also from a cost perspective keeps things under control, right? And I think that's critical, is making sure, and most of my clients like this, right? They like having that, okay, phase one is going to be this public record search. It's going to get us to a very detailed yet focused phase two, right? And it's going to cost X for phase one, and then we'll let you know. So I just feel like not only does it make sense from an investigative point of view, but from a client management, cost management perspective, they really like that as well.
Yep. Which is a great transition, right, to the comments that you prepared for us on how to manage your investigators effectively as a law firm.
Sure. Thanks, Nick. It's working with lawyers for many, many years, first with U.S. attorneys in the Southern and Eastern District of New York. You work with all different personalities and types, but the most important, and I think the most effective partnerships were exactly that, partnerships between the law firm or the lawyer and the investigator or investigative shop, not vendors. And sometimes I think the word can be used just, oh, well, let's just go get an investigative vendor. And again, we don't take offense to that, but we are more than that. And I have found that when we're really working and joined up together, having that back and forth with our investigative experience, with that experience comes creativity, right? And the more we hear from you, the lawyers, about the facts of the case, and candidly, even from the client as well. In fact, sometimes mostly from the client. Sometimes there's little tidbits of information that either you, the lawyers, or the clients don't really think is that critical. And yet, for us as very curious people and experienced investigators, we can take that little piece. And sometimes it's that link in the chain that by itself means nothing. But based on the way we do things, or based on the other pieces of information, it may be that critical link that needs to be, or that can open the door for success with the case. I think another thing that's really important is just, again, it's collaboration, it's communication, it's over communicating. What are the objectives? What are we really trying to do here? What are our expectations? And that's with the law firm, but then also separately with the client. What are the potential outcomes here? And to Ed's earlier point, as in spite of best intentions, and I'm relentless in the sense that I'm always positive that we're going to find that piece of information and I think that's what all investigators, good investigators, have is that undying belief At the same time, you have to be realistic with budget, etc. But really having that mindset where okay, here's what we think we can do. If you have the trust with the lawyers, and the lawyers are coming back and forth, is coming up with that clear game plan, right? Exactly what you are going to do as the investigator and what the law firm expects of you from that phase 1, phase 2, etc. There shouldn't be any like surprises in the sense of, oh, I didn't know you were going to do something like that, right? It should be you all. I mean, maybe good results coming back is a good surprise. That's fine. But I think doing something way outside the kind of mandate or the agreed upon scope is a recipe for disaster. Let's see here. Yeah, and one thing that doesn't happen all the time, and sometimes it's for good reason, is sometimes the law firms will maybe not let us as investigators have that first really detailed interview of the client. And I have found when that doesn't happen, that there is a lot of information that's left on the cutting room floor, as they say, and that can really impact an investigation negatively. If just having the opportunity to sit there, even with the law firm and the investigator and the client, kind of going through the story, will allow the investigator to get really to develop a rapport, B, to really understand the facets of the case and ask questions that perhaps based on that investigator's experience haven't been asked before. And so that's critical, I think. Also for lawyers, keeping the investigators abreast of changes or new information that has come available, whether it be through another avenue of the law firm investigation, that's critical to feed that to the investigator, because that may also have an impact on what the investigator, ideas the investigator may have, or questions they may ask if we're to the kind of boots on the ground phase 2. But working in silos, you hear it across industry, and it's not a good thing, but particularly here, knocking down those walls, having that rapport, that collaborative relationship, and realizing that we're all part of the same team is really helpful. I have found very helpful over 30 plus years.
Yeah.
Some of these other things we've talked about and have been covered by Allison and Ed. But I do think allowing sufficient time for an investigation, sometimes, as you all know, sometimes it takes forever to get an engagement signed up and ready to go. And then the client or the law firm might be like, okay, and we'd like to get results by next week, right? And I think, like, yes, there should be the pressure to quickly get information. At the same time, understanding the process of the building out that bottom of the layer cake, right? And having all of the deep dive public records research to build that solid foundation. That takes time to do it properly, right? To do it well. And then to really think about those and pull the leads out of that and really think about what a focus phase 2 is. It takes a little bit of time. Now, of course, as investigators, we'll move at whatever pace we have to move at, and happy to do that. At the same time, trying to keep the expectations with the client that, listen, we want to, if we're going to do this, let's do it right, and let's build this appropriate. This is how this works. It's a tried and true methodology, and this is how we're going to proceed. So there's no surprises there either. And I'd say, then you can get to the source phase, planning interviews. In general, people like to talk. I have found over the years, and also, there's great ways to get information. Legal ways to get information. Showing empathy, to whoever the subject of the interview is. And I'm not talking about a hard-hitting interview against say, the defendant or someone like that. I'm talking about people that have information in the link or a link in the chain, working very closely with the law firm and making sure that it would be okay to approach someone like that, but doing it in a way where you're not just winging it and instructing them, go in fully prepared, and what's your game plan for that type of interview. That's somewhat separate and apart from just identifying sources. We all have networks of sources in places, in countries, that have information that they can get or know where to go to get information. That's slightly different. And then, most importantly, I think is reputation, right? The lawyers, you want to keep your good names. We want to keep our good names. So, making sure it's very clear, and a lot of times we use subs that are in a particular country that perhaps we haven't, worked with before, or even if we have, I think Gretchen will get into this more, but it's making sure that they're aware of how you operate that the high expectations to keep things on the up and up, right? And many places, I've been at Exeger and now at FRA, is having our subs sign off on our anti-bribery and corruption policies and kind of making sure that they're not, it's not that the lawyers need to know like who the name of that person is that's in Morocco pulling that piece of information, not that, but having the trust that we as the investigators, the people that we're using, are operating to the same level of integrity that we ourselves operate at. So I'll pause there, Ed, or fellow panelists, if there's any feedback or comments.
Well, I will say that I'll pick up one point right off the bat, and that is that I believe in full disclosure to the investigators. I want them to come in and be part of our team. Some of you have sat in our offices where we do collaborative meetings and we figure out what's going on together. And I think that's the most important thing of all, is that we are having people as partners, and we then believe in a written tasking memorandum. And so now I realize that at any given time, I'm running between 10 and 15 investigations. You cannot keep all those balls in the air. It's impossible. So I was getting angry with investigators because I was having to chase them, as opposed to, I don't want to chase them. I want them chasing me. But then I realized I was the problem, not them. I was the problem because I had too many balls in the air. So one of the solutions I came up with was we hired, and we've now had for about 7 years, director of investigations. Not it's Will Nichols. Not because we were trying to take work away from investigators, but because someone has to be the interface, a seamless interface between the legal team internally at our firm and outside with the investigators. Now, still, as a lawyer, I have a lot of interaction. All of our lawyers do. They're all running investigations, and so they have a lot of interaction with the investigator directly. But we found that was a solution for us because we wanted to have more interaction. We didn't want to be chasing folks, and we are always the one getting the call from the client first, saying, "Hey, where are we on this?" And then we have to then chase downstream and say, "Here's where we are." Or where are we on this? We say, and then it gets echoed down line and then back upstream. So we don't want to have that happen. So just to pick up on a couple of other things, by making people partners, really deep partners in the case, there are links. So one particular case, I think these things are more realistic when you give examples. We had to establish a link between target A and target B. Okay. And the investigator was brought under the tent and told, here's why. Here's the legal reason why we need to do that. And they found a one-line fax line that established, because we couldn't find any communications between target A and target B. They found this one fax. They then drilled down into that fax and they found that is a fax machine in target B's office. So now we've got the communication, we've got it. We are showing that they are communicating, and we figured out how, but that was something that would have never happened if we hadn't put everyone in the same room and talked about it, or even virtually, I'd say in the same room. That's my personal preference, is have people physically there, but I realize we're in a new world, so we do a lot of it virtually now. But having them together helps with that. Now, one of the things we very much want to do is get you under our attorney-client privilege, right? The investigators, because we can do a little bit more, we can defend more, we can somewhat block investigations into our investigation, because a lot of times what happens is the other side launches an investigation into the investigation. right? And now they want to sort of put the investigators on their back foot. They want to put the lawyers on their back foot, the client, and they're trying very much to show that something untoward was done, because they think, how could they have possibly gotten that information without violating some of my rights along the way? And lots of other of clients on the other side. And even those who know darn well how we got it, they still do it because they want to create the impression in a judge's mind, because judges are people and they don't necessarily know, and they watch NCIS too. And so they may very well come away with the wrong impression that somehow we did something improper. All right. So we'd like to get you under the privilege. And that's complicated when I recognize that sometimes you guys are the first responders, right? You're the ones that get the call first from the client, and then we come in after the fact. I think one of the things we have to think about is how we can bring you under the tent as fast as possible, so that you can be within our privilege. And then the last point I want to make is on the interview process. Roy and Allison both picked up on the human intel. No matter how much empathetic you are, no matter how much you try, and no matter what a nice person you are as a lawyer, the minute you say, I'm XYZ lawyer, the shields go up, right? Mm-hmm. Shields clients like, oh, lawyer, nervous. I'm nervous. There's a lawyer. Mm-hmm. So you have to be very careful that you don't, So using an investigator to do those interviews opens up the subject, I think, to talk a lot more. So I know I'm gone over, but sorry.
No, that's fine. I just see that time is flying, but thanks a lot, Ed. Sorry. And I fully agree with the disclosure. The one thing that I want to say, I alluded to that earlier, is that being a lawyer myself in private practice and then switching to investigation a long time ago now, I've seen the difference in terms of how people think. It's really a cognitive the difference between the two. And that's why you want to have both sides having all the information, because they will process that information differently. We have one more topic left, Gretchen, which is once you've got that information from your investigators, how do you make sure it's correct? How do you assess that information? And how do the investigators themselves do that? Gretchen.
Thank you. So I think that this is a core part of the work. I mean, we talked about open source information. I would say that largely for the purpose of this discussion, we can rely on open source is proven. It's a record, so we can put that aside. I think that the information that we should look at as the source, quote unquote, information that comes from either a subcontractor or a source, which I think that's the first thing to differentiate between, at least at Vantage, we consider a subcontractor someone who works in a specific jurisdiction or performs a specific service, and probably not just for my company, but probably for many of you. And they operate in a way they can access certain records that it would take us more time and be inefficient to access. But sometimes those people actually also offer source services, and they'll go out and conduct interviews, and often they don't tell you actually the names. They'll give you some description, and so you don't actually know, the degree, specifically who they've accessed the information, and they will return some sort of commentary. Separately, a source we consider to be someone who has a direct interest in the matter, who has specific information related to the objective of the investigation, former employee of a target company, former business partner, current business partner, former spouse, someone who has direct information and can attest firsthand to the topic. So I think with regard to both of those situations, I think when a subcontractor returns source information, we're much more skeptical because we haven't conducted the interviews ourselves. And so you really have to verify and test this information. We've had a situation where a subcontractor has come back and told us that a bank, several banks were running a certain system and it was relevant to our clients. We happened to work for one of those banks, and we went directly to the shareholders and former managers of the bank, and they said, "We've never heard of this system. We have no idea what you're talking about." So we were able to completely disprove, well, I mean, unless our clients were lying to us for some purpose, but at that point it's too questionable to rely on in that level. So I think it's not that subcontractors can't produce accurate source intelligence. It's just that I think if they aren't declaring who they're actually speaking to, and if it's kind of a very obfuscated, you really have to think very carefully or try to do in some manner to corroborate that separately. Sources, on the other hand, I think, and I don't mean people who have been told to talk to you because a lawyer or someone has told them to talk to you. I mean someone that you've identified through research, and then you figure out a way to approach them legally, of course, and using some sort of figuring out why they might be interested in speaking to you and playing on that, ideology or maybe anger. Maybe they were fired, and they have some sort of axe to grind with their former employer. Those people, typically you can validate their information a lot more clearly. Often they have actually documents, or they can point you to actually information. They can point you to public records that you wouldn't have found if it weren't for them. Asset tracing is a great example of this. So if we were looking for the assets of a person who ran a commodities company who defaulted on a large credit trade loan, and they had fired a PA just before COVID. She had not been paid for, I think, 6 to 8 months. And so she was actually very angry, and she was happy to tell us which houses this person owned that we wouldn't have found easily, if ever, banks that he and the family used, and other information that was highly useful for asset tracing. So I think it's very important to differentiate between source and then subcontractor source information. I mean, also in terms of just information and generally as you reported to the clients, is bias. So making sure that your own, if it's more of not just asset tracing or fact-based, but if you're trying to determine something a little more less specific, not letting your own assumptions at the beginning force you down a path that's actually not right, and then you ignore information that could lead you to a different conclusion. And then I think finally is just being honest. So I mean, when you collect what we would call intelligence that's not verified, and you've tried to corroborate it, but you think maybe there's a chance it's accurate, there's no reason not to keep it from your client necessarily. But saying that it's absolutely true and standing behind it and then looking like an idiot later is not the right way to take it. So I think it's very simple, is just to be honest in your reporting and qualify things to the greatest degree possible.
So this is the scariest thing.
Yeah.
This is the scariest thing for us because we're going to be at the coalface. We're going to be standing at a podium at some point telling a judge or questioning a witness. So we need to make sure from our standpoint that we've got good, solid information, even if it's for cross-examination and we want to make sure that it's going to resonate, or if it's, information that we need to make a link in a case. So we really like to triangulate as much as we can. Can we get multiple sources if possible? And obviously you guys do too. We know that. It's not like that's a unique thought, but we're really pushing back a lot. It's not adversarial, but it is, it's collaborative, but we're pushing back to say, we need more. We need more. We need something more than that because, but now accepting at some point, there's no more. That's it. You're gonna have to make a decision. Do I use it or do I not use it? Is it information that we can test in any other way? Can we see something about that information that doesn't make sense? Right. So the other thing is when you are gathering information, one of the things that I've seen is that the frontline lawyers, a lot of times we're brought in as special counsel, whether it's for a bankruptcy trustee or bankruptcy counsel or in a high net worth divorce or in a high net worth probate case. Many times we're the first person to sit down with the aggrieved, the victim, and actually let them just talk. Let them talk for hours. Sometimes involving, in many of these high net worth divorce cases, it's a cathartic process, right? They're and they have information, but no one's listening to them. And so one source that we like to really think about is the individual, the client. And to pick up Roy's point earlier, we don't have a problem having an investigator in those meetings, but we also don't want to cast of thousands either, because it's very intimate and it's hard for people to really come out and divulge information when it's like that. So the reason I bring this up is that we've worked the case in the past where, and this always mostly comes up with bank information, where subcontractor information comes in and it's unreliable or it's unverifiable. And unverifiable for us means that it could be very much wrong. And so as someone who's gone to court twice in my career and had it blow up in my face with bank account information that was just wrong. I am very, very skeptical. I think Gretchen's word skeptical really resonates with me, sort of professional cynicism, if you will, or skepticism, to push back and make sure that we're getting as much information about how the information was procured as we can, right? I do think that's sometimes investigators think we're trying to probe into their sources so that we can use the source directly and cut them out. That's never going to be our case. We're never going to do that because it would be disaster for us to do that. We don't want that information because we're going to be the one standing in front of the judge. By the same token, we need to know more. And so I think developing trust with investigators so that they can share that information, so that they know that it's not going anywhere and you're not sharing it with other investigators and you're not sharing it and you're not going to just go directly to that source is critical. But we do very much want to get multiple inputs as to key facts and not just rely on a single source, whether that's a subcontractor or however you want to describe them, a stringer. That's very, very important to us. I'll stop there because I know we're right at.
Yeah, I was about to say.
That's a good spot. Yeah.
Yeah, thanks a lot. We've got 7 minutes left and we've got quite a few questions from the audience. So I suggest that we open to that. The first question that we had was, what is on most occasions the most challenging aspect of an investigation? I'll let you guys say what you think. To me, the most challenging part of the investigation often is the client. Especially as you mentioned, or someone mentioned earlier, if you're dealing with a client that is not accustomed to that, which is the case mostly, even if the end client, I'm not talking about the lawyers here, but the end client, if the end client, even as a big corporate, they may not be, the interlocutors, the people may not be accustomed to that, and they can be very clumsy. And it happened to us, I mentioned it on the prep call, to us recently, where we were in the middle of a complex investigation in the assets of a person, and then the end client thought it was very clever for them to contact the target directly to ask some clever questions. And the clever questions were not clever at all. It just started raising all sort of alarm bells with the target, and it nearly derailed the investigation. So that's really one of the most challenging aspects. Anyone has another idea?
I think asset tracing in general is a challenging topic, because assets, I mean, beyond like our corporate affiliations and some property, I mean, frankly, the bank account stuff is very difficult to figure out. Other types of crypto trading, brokerage accounts, art, luxury vehicle, I mean, all of it would be great to be able to map out, but especially when you get into high net worths, I mean, or even other vehicles, I think asset tracing is often very challenging process. And it takes more time, and it's also more expensive than I think a lot of clients are kind of prepared to understand. So that's one thing I would say.
That's what I was going to say too, is there's a lot of work that goes into this. And sometimes I think because of the TV shows or what have you, they think that things can be done A, by the next day, and B, for, dimes on the dollar. And so, really working with the law firm to make sure that everybody's on that same page of how this, especially for a full blown investigation where you're going, a lengthy investigation can be costly. One other piece to that is, overt versus covert, right? A lot of times we stay covert until such time that, the law firm or the client feels comfortable with going overt. Overt might be important because really what you're trying to do is drive the other party to the table, to the negotiating table, to just make the payment. So like you start knocking on enough doors and you start finding some assets, you might want to do it in a little more noisy of a way, not in an inappropriate way, just in a way that's overt. But that needs to be planned out clearly with you all, the lawyers, to make sure the steps that you want to take and that what you're comfortable with. I've had a lot of success where, going in and actually making people realize that they're not going away and that they're taking serious steps. The client is taking serious steps, that it has driven them to the negotiating table and there has been a settlement reached. So sometimes there can be success earlier on in an investigation if you do go over it. But again, needs to be, you don't want your investigators doing that on their own without, planning that out.
Just one quick point. You have to tell your client to contain the information, right? And it's not obvious at first. You think, well, why would they ever say anything to anyone? Well, in a high net worth divorce case, there are children many times. And those children sometimes get told information, and then they tell it's dad. Oh, it's almost always dad. Let's be honest. It's the dads we're chasing. And so then we had a case where we rolled a 5-person team into Beirut to surveil this guy, and the kid tells the father, "Oh, by the way, mom's all over this," and we're like, "Oh my God!" The expense on that was amazing because we knew he was going to the banks. That's where he was doing his work, and we wanted to know they're targeted in, and so that basically blew that entire piece of the case, all because mom decided to share information with her oldest son, who decided to, take it upon himself to say, "You better take care of mom," and it just set us back. We ended up getting a good resolution in that, but it was one of those mortal blow. We thought mortal blow at the time. So I know I want to get other questions in.
Yeah, and you understand that because in those cases you've got a lot of emotions, of course, around. But surprisingly, in
100%.
commercial cases, that can happen too.
Absolutely.
Emotions. We have another great question. Could you explain? It's a long one. Could you explain the step between public records and going to human sources? What kind of information and clues are you looking for before making the step? You mentioned blowback and counter investigations as a risk. Are there any others? Alyssa, do you want to take this one?
Sure, yeah. So I think, as I said earlier, the public records is usually the first step, just to see what we can find, and that might give us some more directions, give us some ideas of questions to ask human sources. Might be better if I give you a recent example of a case I worked on, which was an asset tracing on a Saudi businessman. And we looked in the public records, so we could see his UK companies, his shareholdings. We found a UK address. And we could check and look at the ownership of that property. We found he owned it. But it was only when we actually went and talked to people in his circle in Saudi Arabia. We were saying, okay, does he sort of travel somewhere for the summer, as is quite common for people from Saudi Arabia to do? How does he get about? Does he have a private jet? That we found actually he also had a house on the French Riviera, and he did indeed travel there by private jet. So I hope that's sort of a practical example of the difference that you might find between public records and the information we hope to get from human sources. It's not always that easy. We were very lucky that we just found a person who had the information we wanted. And I guess it comes back to Gretchen's example. You do sometimes need that bit of luck of the aggrieved ex-employee. But that's sort of the kind of thing that we're hoping to find by talking to people.
And sometimes to build on your example, sometimes the human intelligence can lead you to the public intelligence. We had a case where we thought, it's a long story, but basically we called the office of the target, and then the secretary took the phone and said, "Oh no, you'll never reach him at this time of the year. He's always in his house in Mallorca at this time of the year." I thought, too bad. And then we went to the land register in Mallorca, and there was the house.
That's you would have back into the public records to confirm the ownership.
Exactly. So you go back to the public records.
Between the two.
It's not something which is sequential. It's always an iterative process, which is which is difficult.
I'd use the word relay, but yes.
Absolutely. We've reached the end of our time. We have a few other questions. I'm sorry for those. Thanks a lot for everyone for attending. We had at the peak 103 attendees, so thanks a lot. We're very grateful and humbled and honored. Thanks a lot to my co-panelists and to TL4 for organizing this, and see you next time.